This is the Local Public Safety Coordinating Council meeting for July. It is a big meeting today. We're going to hear about the judge's approach towards mental health services and responses. Well, Your Honor, we're very lucky to have you here, so I'm going to invite Judge Cromwell up to speak as our first agenda item.
So I apologize because I didn't do a PowerPoint or anything. I'm just going to kind of give a brief rundown about where we are with our mental health court and our aid and assist docket, and just give an overview of numbers, kind of who we're looking at for those types of programs, and if anyone has any questions, feel free to interrupt me while I'm talking afterwards, however you want to do that. So for the first 6 months of 2021, we've really started to kind of rebuild our mental health court team. So first I'm going to go into the mental health court. And because we've got obviously a new judge took over in January, myself, and then we also have a new probation officer on the team. We have a new liaison from Jackson County Mental Health and a new liaison from Medford Police Department. And so we've also added a few team members onto there to really kind of keep us accountable and so that we're actually consulting with the people who that we're assisting as well. And so that includes a member from NAMI, who's also a veteran, and then we also have a certified recovery mentor, or a CRM, from the ARC, who has not only lived experience with mental illness, but also was in the criminal justice system and actually in prison in the past in California. He is by far, I would say, our most valuable member of our team, because he is just he's incredibly helpful in dealing with our clients and helping them. So part of the rebuilding process that we've had in the first 6 months have included a number of breakout sessions. So we not only have our weekly meetings and staffings that we do, but we've also had a number of breakout sessions, which are couple-hour sessions where we'll discuss not only going back to the roots of what the evidence-based practices are for mental health courts, but and also to discuss our team roles, the team members' roles in that mental health court. We've had presentations by a local psychiatrist, Dr. Mann, who has discussed with us more of harm reduction approaches and less necessarily punitive approaches, because they tend to be better long-term for long-term recovery. And we've also had important racial and ethnic disparities discussions, or RED discussions. This was something that needed to be done for a long time that had been kind of put on the back burner. And we actually just completed a couple of cultural agility trainings with Hilda as of yesterday, and it was just really impressive to see. We've got total about 12 people on our team. There were probably about 9 or 10 at this training, and just to see a group of people from a variety of backgrounds, social services, law enforcement, prosecutors, defense attorneys, be able to have just really meaningful conversations in a really positive way, and just be able to hold space for each other and really have those really important discussions. So those are some of the team building stuff we've been doing. We've had consistent referrals this year for our mental health court, and we're close to our cap of 20 participants. Currently, we have 2 pending referrals that haven't been staffed yet. We have 18 participants in, and there's 1 additional that's been on abscond status for now a couple of years. So currently 18 participants. Only 2 of those 18 right now are women, which is actually an odd dynamic for us. So we've had 9 graduations within the past year. We have 2 more coming up in the month of August, and so it's been actually very positive. I wanted to give a brief intro into the type of people that we'd like to see in our mental health court, because it's not necessarily who people expect us to take. We oftentimes get referrals for people who have just, kind of a one-off incident where they have suffered maybe a long time, or have been medicated and appropriately addressing mental health concerns, and then for some reason go off meds and then have a psychotic episode. that oftentimes those folks do not have criminal histories, and this is not the participant that we actually want to see in mental health court. Even though we'd like to see those types of people get some type of reduced sentencing or guilty except for insanity type of situations, depending on the seriousness of the case. And the DA's office has been really wonderful about dealing with those types of individuals. But the people that we want to see in mental health court are high utilizers of the systems, whether it be the hospital system, the criminal justice system. The people that are, quite frankly, really difficult for our community to deal with on a regular basis.
Judge Cromwell, can I ask you a question about that?
Absolutely.
So are the majority of these people high DSM level diagnoses, like
Yes.
paranoid schizophrenia?
And that's a great,
bipolar disorder, or are they mostly personality disorder?
We do not take personality disorders, and that's a really good question. So you have to have a serious and persistent mental illness, and that is not personality disorders, not solely drug use, although we do see a lot of dual diagnosis. But these are folks with schizophrenia, schizoaffective, bipolar disorder, most commonly those three. We do take folks with major depressive disorder and serious anxiety, but only if it has a psychotic component to it. Because normally, under normal circumstances, those other folks are not as engaged with our criminal justice system due to mental health issues. So we like to see medium to high criminality or criminogenic risk, so people who have criminal histories, or prior involvement with the criminal justice system, anywhere from low, medium to high on substance use issues. So again, we see a lot of dual diagnosis, and then medium to high mental health acuity. So folks that have used the hospital a lot, have prior hospitalizations, and the serious and persistent mental health disorder, not personality disorder.
So they're all people that can be treated. I mean, essentially,
Yes.
and are they almost all on some kind of medication regimen?
Almost every single one is on some type of medication regimen, and if they're not, it's almost always because they were probably misdiagnosed before coming in, and we're not going to boot those people out just because they've come in, but almost everyone is going to be on some sort of medication. So the kicker is that even though we like to see, high criminogenic risk, the kicker is that there has to be a nexus between the mental health disorder and the crime that they're accused of. So, for example, not selling drugs to support or committing property crimes, let's say that, to support a drug habit, but rather maybe committing a property crime because you're manic and unable to control it. So that type of nexus is what we like to see. And so, again, these are people in our community that have been exceptionally difficult, both for law enforcement as well as our hospital systems. And I do want to highlight just one participant. It's all, our mental health court is open to the public. It's all public record. And so one of those participants, which law enforcement will know, is Soren Steele, and he is, you would never believe this guy in mental health court, because he is somebody he's in his mid-50s, for those of you who don't know him. He's in mid-50s. He has been in the criminal justice system and had horrific alcoholism probably since a teenager, and has been really on our radar for quite some time. And in 4 months, he's 4 months into the program. He has not had one sanction, which is actually surprising. We were really nervous to take him in because we just didn't know if we were going to be able to address, him correctly and be able to address his issues correctly. But he is probably the most, when you get to know him, incredibly compassionate, just really charming, and just a really modest individual. And he comes into court, every week to start with, and just every time, just huge smile, huge toothless grin of like, "Hi, Judge Cromwell, I'm so happy to see you," and just really an amazing individual. And he has done so well. So I don't know It's unusual, and I'll discuss this in a moment, for somebody not to relapse during the course of our program. We expect that, and it actually should happen while somebody is in our program versus when they're out of our program, and because we're needing to, build those muscles of how do we deal with this effectively? How do we get, prevent you from sliding all the way back down? How can you catch yourself before you get there? And so he's done wonderful, but I suspect at some point he'll probably have a little blip on the radar, but he's just really, for anyone who knows him, is just a night and day. So we recently increased our program length from 12 months to 18 months. And the reason we did that is we really wanted to see longer recovery or lengthier monitored recovery before people were going back out on their own without this team surrounding them. So the reason is mental health recovery, substance abuse recovery is not a linear process, and for different people it goes different ways. And so again, similar to what I just said, is we want, if somebody is going to relapse, if somebody is going to have crisis, we want that to happen while they're in mental health court so that we can work on those tools. So let's see, that's all I had as far as the mental health court docket. I don't know if anyone has questions for that. Yeah.
So are you tracking people like 3 years after the program, 5 years after the program? Are we doing anything like that?
There is some tracking going on, and to be completely candid, and I haven't looked at what it's been after the fact. I know it's being tracked. I think you're going to see, as far as the recidivism rates between our drug court versus mental health court, you're probably not going to see as high a success rate. And the reason I kind of attribute that to the fact that and mental health courts anywhere don't have the success rate, and I think a lot of it is just trying to keep people, for a period of time, is preventing them from falling back as low as they were into full-blown crisis. But with drug use, and this is anecdotal, this is not based on any type of information other than my own thoughts, it's a little bit easier, I think, to avoid your triggers if you're suffering from drug addiction, or to go through treatment for drug and alcohol use and not be, let me not go into a place where I know I'm going to be triggered. Let me not go into a bar. Let me not go into, a neighborhood that I know that I've used in previously. With mental health issues, that's it for the rest of your life. You have that diagnosis, or at least these folks have that diagnosis. It's chronic. These are chronic illnesses. And so you can't escape that. And so it's not a matter of avoiding your illness, which part of, that's, I think, an oversimplified version, but that's kind of my idea as to why that our results aren't going to be as good. That's also part of the reason why we lengthen the process, is to get a little bit more, monitored recovery. But it's a good question. Anybody else have any questions before I move on to aid and assist docket? Okay. So on our aid and assist docket, Judge Mejia and myself rotate every other Tuesday afternoon. So we have a dedicated Tuesday afternoon docket for aid and assist. And on April 1st, we began we're probably the third or fourth county in the state to begin a rapid aid and assist process for criminal defendants who are lodged in jail that have been determined that they are unable to aid and assist their attorney in their own defense due to a qualifying mental health disorder. So they're unable to even resolve their case, either through trial, or through a plea, or through whatever motion work. So we've had the dedicated docket, aid and assist docket on Tuesdays for a couple of years now, but the new addition is really intended to prevent people from languishing in jail needlessly while their attorney is, first of all, recognizing the issue when they go in to see them, then trying to get funding from OPDS to get an evaluator on board, locating that evaluator, scheduling that evaluator, and then waiting for a report. And before our rapid aid and assist docket, probably one of the more extreme cases, but was about 6 months between going into the jail and recognizing that there was an issue to the date that we got the report. And that's ridiculous, not only for our jail capacity, but also for somebody languishing from mental health issues and sitting in a solitary confinement. So
Does that docket cover civil commitments too, or just?
no, civil commitments is completely separate, and that's a non-criminal process based on, for those of you who don't know, I'm sure you do, but that civil commitments are based on people who are unable to either meet their own needs that are required for living, or are dangerous to themselves or others, and that's a completely non-criminal process. Now, as we know, it's really difficult. The laws in Oregon are very difficult to find somebody under that non-criminal civil commitment, and so a lot of those people come into the criminal justice system, unfortunately. So with the new docket, we're working with Dr. Orphan with Lithia Forensics, who he volunteered to do our our rapid aid and assist docket. And basically what it is that he has time slots kind of reserved up front for us, so that if once he gets a referral, he can be in, and usually he does video because he's located out of Portland, but he'll do video visits generally. And evaluations by video. So he can get in there before he actually receives funding from OPDS. So the defense attorney will apply for funding, just let him know that they've applied, and then he goes in there before he actually gets that funding, because he works with them regularly and kind of knows that he'll be reimbursed. So that cuts down significantly on the wait time. And he and his team are getting reports done. Between referral to actual report in hand has been about 6 days on average. So it's really amazing. After that point, the person is required by law to then get a community restoration evaluation, which basically can this person be safely restored in the community by taking legal classes, ongoing meds, ongoing treatment, or is this person dangerous enough that they have to go up to the state hospital? So that community restoration evaluation is the next piece. And that has to be done within 10 judicial days if they're lodged. Yep. Yeah, go for it.
So these are people who are unable to aid and assist at the time.
Yes.
My understanding is most of those people, if you refer them to the state hospital, they come back at some point.
Yes.
And it's a very, very small percentage. I think it was even less than 1% of people that are found guilty except for criminally insane.
Yeah, so this is not exactly, and guilty except for insanity is somebody actually has to have capacity, so have mental health capacity in order to make the determination as to whether or not they even want to go guilty except for insanity. So guilty except for insanity deals with their state of mind at the time of the crime, and aid and assist just deals with their state of mind at the time of our judicial process.
So can I ask you how many people on average are on your docket? You said every Tuesday, right?
I'm gonna give you some numbers here in just a moment. But yeah, no, it's significant. So currently, as far as rapid aid and assist, now again, these are only lodged defendants. We have 16. We've had 16 rapid referrals since the beginning of the program, which started in April. And so it's about 4 per month that we're seeing on the rapid docket. We've had as much, though, as 7 in a 2-week period, so it kind of goes in waves. But on average, which is what we were expecting, we're looking at about 4 per month for the lodge folks that go on the rapid program. Now, Oregon State Hospital backlog is, it continues to be just horrific. There's a couple of reasons for this. COVID and the safety protocols surrounding COVID really backed up a lot of the cases from going up there. They're taking I think they're taking 0 civil commitments right now. The guilty except for insanity cases, from the time that they are found guilty except for insanity and they need to go to the state hospital, I've heard it's over 6 months. And for our aid and assist docket, from the date, there's a federal case that says from the date that we sign the order finding them unfit to proceed to the time to get them to the state hospital is 7 days, 1 week. That is not happening right now. And the reason that the Oregon State Hospital is not currently getting in trouble for that or being held in contempt, which they have been in the past, is because of the circumstances surrounding COVID. So it provides an actual, there's an excuse for it, I guess. This is a really terrible way of saying it, but yeah.
So can I just make a point?
Yeah.
I asked that question on purpose because, we have an issue with jail overcrowding.
Absolutely.
There's this big push by mental health advocates that if we can just divert the people with mental illness away from jail, then we'll have all this capacity we won't need in jail. You just said 4 a month is what I think you said.
4 a month for rapid. Now, somebody does not have to choose to go with, there's no requirement that they have to go with the rapid aid and assist process. They can go hire their own evaluator. So there's probably a few more that way. I'll explain why. Let me get to the stats and then I'll answer this question because it's important. What I'm hoping is that, so right now, but for our aid and assist population, it's taking about 2 to 3 weeks for them to get up to the state hospital currently. It's been as much as 4 during COVID, during the major rise in COVID cases. But currently we're about 2 to 3 weeks, which is not great. As of today, we have 43 defendants so far. This is 2021 numbers. 43 defendants with 104 aid and assist cases that are pending. About 79% of those folks were placed at Oregon State Hospital or are waiting to go up, and 21% of those are on community restoration. Similarly, about 20% of those defendants, their most serious charge is a misdemeanor. 80% of those defendants, their most serious charge is a felony. That's what we want to see as far as majority felony cases. As of this year, we've had 271 aid and assist hearings, and that could be a number of different things. That could be the initial finding that they're unable to aid and assist. That could be a 9B hearing, which is when the state hospital says, hey, they're up here, they're not restored yet, but they're not dangerous, so you got to take them back in your community. Those types of hearings. It could be 7-day review hearings, which when these people are sent up to the state hospital in 2 to 3 weeks, and it's supposed to be 7 days, we have to meet with them every 7 days to make sure that there's no other alternative means of handling the matter. Able findings and never able findings. So meaning somebody comes back from the state hospital, they're found able, we proceed forward with the case, or they come back from the state hospital and their mental health status is so chronic as not likely to change, and then they're found unable and the case dismissed. So 271 between all those types of hearings. We're 6th in the state right now for aid and assist cases, which actually is probably where we should be. We've been up at 2nd, right behind Multnomah County, which for our population was not great. Here's where this comes into what you were saying, is the reason why I think we're now down to 6 is that the DA's office has been cautious about not necessarily issuing every single criminal trespass and disorderly conduct case. Here's why this matters. It's not a good solution, but when you're facing a criminal trespass in 2nd degree, you're looking at 30 days maximum jail sentence. So
which typically you don't serve. You serve 1 day on average.
We serve 1 day, but we're keeping people on for the aid and assist because they're not able to aid and assist, and so we'll maybe put in no matrix because they're just too disorganized to release. Then you get this rapid aid and assist process plus the community restoration process. You're looking at about 2 to 3 weeks, plus 2 to 3 weeks to get up to the state hospital. They've served their sentence, they get released. For the people that are on disorderly conduct in the 2nd degree, maximum sentence is 6 months. So by the time all this happens, they wait to go up to the state hospital, they get up there, they're not going to be restored within the time period they have left. So there's 0 point, we're just wasting, I think it's $1,200 a day up there to send somebody back not restored and just get released anyway. So that's why the misdemeanor cases, lower level misdemeanor cases, don't make sense. it makes sense for A misdemeanors and above, because they're facing a year.
So you said, if I remember
Yeah.
the number correctly, 48 actual findings of unable to aid and assist in the year.
43, actually, this is current numbers, I'm sorry, that's current numbers, 43 current. We've had 271 hearings, not necessarily per defendant, not 271 defendants, but 271 hearings.
Yeah, I'm trying to get the number of defendants, 40 something.
I'll look that up as far as how many we've had this year.
So just in a month, how many people do we rotate through the jail, Josh?
So on an average month, it's about 4,000.
Okay,
Yeah.
so this is my whole point. And I'm not saying this doesn't need to be addressed, it does need to be addressed. But this view that if we just address these people who are unable to aid and assist or have mental health issues that cause them to act out criminally, then our jail population will be dramatically reduced. I'm not dismissing the fact that these people need
100%.
assistance, but I'm saying that's not really a valid argument. 48 people of 4,000 a month, and this is 48 people since January 1st.
This is 4 people per month that are actually staying in, that we are holding in so that we can do this process. This is not, the general people that most often in and out on some of these. These are the more 4 per month is generally more serious cases.
And most often it's just an intervention to stop whatever the behavior is and they're out. But my point is that we've gone through 20,000 people in our jail and 48 of them have been unable to aid and assist. We would still have a large need for additional jail capacity, even if we dealt with the people who were unable to aid and assist. Even if we held everyone that wasn't held, that was just released.
No, you're right. You're right. No, it's worth the conversation. I'll get you the numbers for the year. Those are current cases that we currently have on. But yeah, no, you're right. I mean, it's certainly worth the conversation. And yeah, so that's really all I had. I hope I didn't go too long. But does anybody have any questions? Any other questions about aid and assist? Okay, so I'm gonna go and do my prep for my mental health docket at 1:30. So I will be
Your Honor,
back.
thank you so much for presenting today.
Absolutely,
Yeah, really
you bet.
appreciate it. It's great to be back in person, and we'll look to see you. There is not a meeting in August, so we'll look to reconvene in September. So in the meantime, thanks all. Have a great day.